talking about guardianships and conservatorships, what they are, when are they necessary, what the process is to achieve a guardianship conservatorship. And as I had mentioned, Tiffany Kudrovitz from our Generations Law Group, she's one of our associate attorneys here. Her focus is mostly in guardianship conservatorship as well as estate planning. All right, so Tiffany, you have the floor.
Thank you. So what we're talking about today are guardianships and conservatorships. I'm going to give you an overview of what they are, when they might be needed, and I will answer questions at the end. There's a lot of information to go through. Before I start, I want to give a standard disclaimer that the information I'm sharing the best practices and what we do, but every single case is different. Every guardianship is different. Every conservatorship is different. And so when you come in, you'll get, if you needed this, you would get really specific advice, but please know that I'm speaking very generally right now. And a lot of the things I'm going to talk about are almost just the best case, easiest scenario to give you the overview, but it's not always quite as cut and dry as what I'm going to talk about today. So just to give you like a very brief overview, a conservatorship is something that where a person is appointed by the court to help another person essentially manage their finances and their legal affairs. So if you're familiar with the power of attorney, which we'll talk about later, it's the type of tasks that a power of attorney could do. But if you needed to deal with real estate, you can get permission for that, or banking, or transferring assets, or managing beneficiaries. A conservator handles those aspects that a person would have in their life. A guardianship is when it's similar to a healthcare proxy, but that's someone who would manage day-to-day care or long-term care, or get permission to move someone from one facility to another facility. And so just know that between the two of those, if someone is appointed by the court as guardian and conservator, they can pretty much keep a person going on as they would otherwise be living their life, managing everything. But you don't always have both. You could have one or the other. When I'm talking today, most of what I'm talking about is guardianship or conservatorship when the individual is incapacitated. You could need those because someone is a minor, but most of what I do, it's an adult who a doctor has said is incapacitated, meaning they can't make effective decisions. We'll talk about it a little bit more later. But mostly what I'm talking about is an incapacitated adult. It can happen in a couple scenarios. One is that they don't have a power of attorney, so they need a conservator, or they don't have a healthcare proxy, so they need a guardian. So someone who has lost competency can't sign new documents, so we go to the court to get them to appoint someone in a similar role. Another time they will come into play is if there's an ineffective document in place. So for example, if there's something wrong with the execution of the power of attorney or healthcare proxy, or if they don't have all of the terms we need, or say that the documents name someone, but that person either passes away or they have to resign. And people resign for many reasons, like if they might have their own health problems, or they might move away, or they might just not have the time. And then another reason, the last one, is concern over fiduciary actions. And that means that there might be someone named as a healthcare proxy, and maybe there's another family member who says, I don't like what they're doing. I don't think they're doing a good job. Or with the power of attorney, I think they're mismanaging funds. There are things that you might notice that someone is doing where you might say, we need to get in the court involved, and we need to revoke this document, and we need to be doing this instead. So those are the types of scenarios that might lead to conservatorship and guardianship in the first place. An incapacitated person, again, a minor is someone who would qualify for guardianship or conservatorship, but specifically with adults, it's someone who has a clinically diagnosed medical condition where they can't receive and evaluate information, and they can't make and communicate decisions. And something to clarify is that people are free to make bad decisions. You can make bad decisions every day, all day on everything. But if you're making them without weighing the pros and cons, without evaluating the information that's given to you, that's when you cross the line. And so sometimes people will say, oh, I just don't like what they're doing. Well, if they're fully competent and they know what they're doing, they're allowed to do that. So a doctor would evaluate them. And that's the doctor is the one who makes that determination that we've crossed over and that we actually meet this medical definition. In terms of whether if it's conservatorship, basically they can't make these informed decisions about their finances or take care of their property or bill pay. And in terms of guardianship, if they can't keep up with day-to-day care or appointments or manage medications, anything that would put them in danger. And then quite often they're just susceptible to fraud, for example, because they don't understand the impact of the decisions they're making. So all of that's the type of information that would go into a doctor's determination that a person is incapacitated. There's a form that I'll talk about near the end that documents this for the court. So I just mentioned this, that guardianship, again, this is similar to a healthcare proxy if you have one for yourself or you're familiar with them. But basically, the person can't make effective, informed decisions about their health and safety. There's a couple types of guardianship. You can petition the court for a full guardianship. And in that case, you're relying on the statement from the doctor to say, this person cannot make any informed decisions at all. I need to be involved in day-to-day care, safety, living arrangements, medication, the whole broad spectrum of everything that relates to their physical and mental health. You can get a limited one, and that's where you say, well, they need help with these certain things, but they can actually take care of what they eat day to day. They're okay to take care of how they spend their time. They can make decisions about what they want to wear, and you can just sort of carve out these places because the court wants people to retain the freedoms and decision making to the extent that they can. And there's you can get an emergency guardianship, and that's if there's something very, very imminent, life-threatening, where court action is needed very, very fast. The court can do an emergency guardianship, and they'll typically do it, depending on the circumstances, up to 90 days. And then after 90 days, you have to come back, and they'll say, okay, we had this temporary emergency guardianship in place to get us through this emergency period. And now what do we do? Do we need a full full guardianship, or are things settled down now? With respect to guardianships, there's a thing called Rogers Authority, and Rogers was a court case, and it has to do with antipsychotic medication. And this is an area where a healthcare proxy could actually be deficient. It's one of those things that might make one not quite good enough. But basically, if a person is going to be receiving antipsychotic medication, it needs to be spelled out in their healthcare proxy document. If it's not and you pursue guardianship, you'll actually get a guardianship with Rogers. And that means that the guardian has authority through the court to make decisions with respect to the administration of antipsychotic medication. There's more forms required in this. There's a treatment plan, exactly listing out the medications. Attorneys file a report that says, based on their family history or what they said to the doctor or what they said to their children before they lost competency, that they would be okay with this treatment if they could make the decision. But there's just more factors that the court weighs in determining if administration of this medication would be appropriate. There's also, in addition to the other forms, there's an annual Rogers report. So each year there's a monitor appointed by the court who could be the guardian, but someone has to go back every year and say, okay, this person is still receiving antipsychotics or maybe not, and there's a determined need. Like the doctor says, he or she still needs to keep receiving them. So that annual review is very important. Otherwise, if it lapses, then you have to go back and get authority again. Another type of authority that's often missing from healthcare proxy documents that a facility may request is specific authority to admit someone to a skilled nursing facility. And it's something where if someone needs to be admitted long-term, you would want to include that in your guardianship petition and in your proposed order and decree, because you want that box to be checked off by the judge at the hearing. They look at the best interest standard. In this case, and actually across the board, I'll talk about this later, but the person who is sort of the subject of this, who might need conservatorship or guardianship, they have the right to object. So at any point, they could say, I don't like this. And the court has a method for dealing with that, which I'll talk about. And if it's just short term, you can do a separate specific filing saying we want to admit them to the nursing home. And then the court will come back to it if there's going to be long-term admission. But that's another possible way. Typically, it's admission to a facility, moving the person from place to place, for example, from the hospital to a rehabilitation facility, or antipsychotic medication. Those are some areas where someone might have an otherwise very solid healthcare proxy, but if those specific things aren't there, it could make guardianship needed. The responsibilities of the guardian, again, it's the healthcare management, and it's whatever the decree and order from the court says. If you're a full guardian, you take full responsibility for all of their healthcare management. If there are limitations, it'll say, okay, the guardian gets to do all of these things, except for what we've indicated on the last page, which might be like daily care and choosing how to spend their time, what to eat, for example. And guardians have mandated court reporting. So even without the Rogers review, a guardian has to turn in a care plan. And it's a 60-day care plan. They write out just basically what they're going to do to take care of the person. And we're going to, set up appointments. We're going to do all of these things. But the court wants to know that whoever they're appointing is going to be fulfilling their duties and also accountable for their actions. So the reporting, you have the initial report that's due, and then each year you have to file an annual report as well. If you have Rogers authority, then the Rogers monitor has to do the Rogers report in addition to the rest of the reporting. One thing is that the guardian it's similar to a healthcare proxy. The guardian should really be acting in the best interest of the person that they're helping. And so they should always be thinking, what is it that this person would like? And not just thinking, well, if it was me, this is what I would do. For a conservator, this is, again, it's about legal, financial, property, business type transactions. And a conservatorship, I don't know if I skipped it or if it's coming up, but a conservatorship is generally needed because the person needs access to money for their care. Their assets are going to be completely wasted if nobody is managing them, or somebody else needs care. So say they have a spouse who depends on them, or they have a child at home. And so we need management of something. So basically something has gone astray with the financial legal side, and we want to take care of those aspects. With the conservatorship, there's also various types. A full conservatorship is basically when the person that you're working with has no ability to manage finances at all. They can't make any effective decisions. They're making bad decisions that are also just uninformed. So there's a lot on the line when a court grants a full conservatorship, because you're essentially taking all full control away from them in these areas. A full conservatorship has to be justified in this medical form of saying all of these things, or they have a condition that's going to be lasting, or they have worsening dementia, or there's some reason why a full conservatorship makes sense. There can also be a single transaction conservatorship, and that means, say that you have a power of attorney, and the power of attorney is good, but it's missing something. Maybe it doesn't have specific authority to deal with real estate, but what you really need to do is sell the house because they need the money for their care, or they're not living in it, or the house is is abandoned and it's falling apart and you just need to do something, you can petition the court to get specific authority to do one single transaction. A lot of times when clients they're applying for mass health and we're helping with that, we will use a single transaction conservatorship to transfer real estate from a married couple to the community spouse so that we can protect it. Or if we need to change beneficiaries or ownership on an account. There are some things you can do using a single transaction conservatorship to assist in that process. You can also get a temporary conservatorship. I think they're much harder to get than an emergency or temporary guardianship, but you might need a temporary conservatorship because the person is going to be evicted from a nursing home because they can't access money, but we know there's an account. And if we could just get to the account, they wouldn't be kicked out of the facility where they are. But temporary is basically, we're going to get you through this period of time. And then again, like a emergency guardianship, you can come back in 90 days, whatever the judge says, and you can say, okay, we had the temporary, now we need to do this, whether that's a full permanent conservatorship or maybe everything is settled down and everything is good. This is also one where we try to focus on independence wherever possible. And a lot of times in a conservatorship, we'll say in the petition, we want a full conservatorship because we know that the person cannot effectively manage their money. They're at risk for people taking advantage of them or just going to the ATM and withdrawing money, and we need these safeguards. But we don't want to completely take away the freedom. So a lot of times the conservator will get them a prepaid card or give them spending cash each week. But those are ways where you can still let the person have some authority over what they're doing, but you're still managing it so things aren't being wasted or stolen or just lost. The conservator, they manage income and assets. They have a responsibility to keep track of everything. You also have to keep separate accounts, so you cannot commingle your funds with their funds. So people will open up a bank account for the conservatorship, for example. And you have to do mandated court reporting. And so if you're guardian and conservator, you have a lot of reports to do each year. But when you're first appointed, you have to give the court an inventory. And the inventory lists all of that person's assets and the value as of the date that you were appointed conservator. So if there's bank accounts or real estate, you put that on there. You have to explain their income, like if they have Social Security or pension or an annuity or rent, like rental income from their property. But you basically give the court this overview of everything they have, and then you submit a financial plan that says, this is everything I'm going to do. This is the income. These are the expenses for housing, legal expenses, medical, everything. And then each year you file an annual report and they're all linked together. And when you file the inventory and each year you do an accounting, the conservator has to account for every transaction out of every account. So if it's interest or a bill payment or a deposit for literally anything, all of those are put on that form. So the conservator has to be very detail oriented because the court is looking for a perfect match in terms of what they had then and what they have now. Does anyone have any questions so far just about like the general need for conservatorship and guardianships? That was more just like an overview of what they are. Okay, so in terms of how do you get this conservatorship and or guardianship, in terms of the court, it's very interesting because you actually file, say that you want both of them, you would actually file a petition for guardianship and you file a petition for conservatorship. And the forms are slightly different, but essentially you're filing two petitions and then a bunch of duplicate forms because the court is considering them as two separate things. By the time you get to the hearing, the matters are combined for hearing, but they might actually grant your guardianship without any issues, but have questions about your conservatorship. So it's something, how I said, that everyone is unique. It's not always as smooth as I'll say here. The general timeline though, it's just a complete guess, but typically 2 to 3 months time from when we file the petition until the conservatorship or guardianship or both are granted. And that's because you file a petition and then you have to wait. They'll issue a citation with what's called a return date. So I filed something a couple weeks ago. The return date is June 6th. I have to do some back work and extra filings and get people to hopefully agree in that time. After June 6th is when the court is going to give us a hearing date. Just because of notice, I know that that hearing is going to be at least 3 weeks out. Because we have to make sure everyone knows about it. So we already know we have at least a month, and then we know we have at least 3 weeks right there. And then the judges are busy or vacations or holidays. And there's a lot of probate court judges, and a lot of them do conservatorships and guardianships. So I don't know how they assign who gets what, but some judges seem to be available sooner and some later, but you don't get to pick. So just know the general time frame for just a standard conservatorship or guardianship is 2 to 3 months at least. In terms of forms, I mentioned the petition, and that's what sets out who you are, that the one person applying, who the person is, and they're either called the protected person or the respondent, depending on if it's guardianship or conservatorship. It says, who are you proposing to be conservator or guardian? And it might be you might be filing it on behalf of someone and you want to be that person. It might be a professional like an attorney. It might be a social worker or just a professional who always serves as conservator or guardian. Or it could also be someone appointed by the court. So we typically can find someone who's available between us or professionals we know. But if you have no ideas, you can ask the court to appoint someone. The rest of the petition is just background information, like who are the interested parties, and there's a statement of who that is, like if they're married, if they have kids, if they have a healthcare agent or power of attorney, if there's a representative payee. All of those are the types of people who would get notice. If someone had care and custody of the person in the last 60 days, they would be an interested party. But it's basically people who would be able to look out for the person that we're initiating this proceeding to benefit. So the petition is a very important document because it really lays out everything. Two other things that are very important are listed on the screen. One is a medical certificate. So a medical certificate is it's about 8-page form, and it has to be filled out by a medical professional, like a doctor. It could be like if someone's at the hospital and someone could fill it out, their primary care physician, they have a psychiatrist, a nurse practitioner, someone who is very familiar with their current health history and their status. But the medical certificate is what sets out, this is their general health, this is the progression that we anticipate. They need like 24/7 care or memory care or assisted living, or they're fine. And it's basically saying this person has, like, these facts support this person being incapacitated. So it's a very important document. There are questions specific to guardianship, and there's ones that are specific to conservatorship. And in some cases, I've gone in for a hearing. It's very rarely this easy, but 2 times the judge flipped through everything and looked at the medical certificate and said, the medical certificate speaks for itself. And it's, yes, Your Honor, it does, because the doctor did such a good job of detailing basically everything that we were concerned about and why conservatorship was needed at the time. So the medical certificate can be challenging though, because it's only valid for 30 days. And so when we're filing and someone has an appointment for a medical certificate, we know that we have to file everything with the court within 30 days of that appointment. And so we try to get things together as quickly and efficiently as we can, because that's our deadline. Then you also have to have a new medical certificate before the hearing or for any future hearings. So say you're pushed out 90 days, you need a new medical certificate. If you have another hearing after that, a new medical certificate. So it can be a lot of work for the doctor, for example, just to be keeping up with the medical certificates. And another one I wanted to mention are the bond forms. So a conservator or guardian can serve without sureties on bond. And sureties on bond, it's basically like an insurance policy saying that I'm accepting the role of conservator and I don't need an insurance policy to guarantee that I'm going to do my best actions and there's minimal assets and everyone who's interested agrees and has signed a form and I'm trying to waive them. So in the best case scenario, you can do a bond without sureties, which the judge signs and you don't have to worry about paying an annual premium. Sometimes though, depending on the assets, or if not everyone agrees, or it really just depends on the facts, but they'll make you have sureties on bond. And in that case, sometimes it's personal sureties. Say that the estate of the person you're helping is $2 million. Well, if there's a person who has $2 million and can guarantee your performance in that fiduciary role, they could sign it. But typically it ends up being a corporate bond. And so we work with an insurance company who works with an underwriter and essentially you pay an annual premium for bond. So the bond one can be very important because if you can't get bond waived, it's just another expense added to the estate. But just you should be aware of that. And then also I wanted to talk about notice to the protected person or respondent. So that's the person who would be sort of under guardianship or under conservatorship. They're going to get notice of everything. So when we file the petition and any motions, say that we're trying to waive bond. So the attorney files a motion to waive bond. Or say we want counsel appointed. So there's a reason for an attorney to be involved for them. Or we want a guardian ad litem appointed. Any of those types of documents, that person is going to get a copy. In addition, and they have to have that served in hand. And so some facilities they're allowed to hand it to them for us if they're not an interested party. A lot of times we have to hire a constable. The people we work with are very wonderful and they're used to working with people, for example, with dementia, who would find it confusing or potentially scary to have someone handing a stack of papers and they don't know what it is. But we have to give them notice. And sometimes people will say, why do you have to give them notice? They're not going to know what to do. And it's really because the court wants to make sure if there is someone who has a valid reason to object, whether it's that person or someone else who's an interested party, we want to give them that opportunity because we don't want this slipping through the cracks because someone sort of railroaded themselves through without involving anyone else. And all of the interested parties, and I talked about that before, it could be their spouse or their children, their healthcare agents. I had one where it was a lot of cousins. That was the first line of family members. Whatever it makes, just the form tells you exactly who needs to get it. You just have to fill it in and piece it together. But all of those people will get notice as well. So they're going to get a copy of the petition and relevant motions. And then once the hearing date comes up, I told you before that we know the hearing date's going to be about 3 weeks out from the return date. We have to give notice we have 2 weeks before to the person again and to all interested parties. Let me see if the slide is next. Yes. Okay. And that's because all of the laws changed back in 2009 and everything in the probate court, especially these guardianships and conservatorships, they really want to take care of that person, the incapacitated adult or the minor child who cannot make their own decisions for some reason legally. We want to make sure they get full information, that they can object if they want to. They have a right to counsel. And there are sometimes when counsel is appointed, like with a Rogers guardianship, counsel will be appointed. Right to notice, to be present. And some of these factors are included in the medical certificate. So it will specifically ask that medical provider, do you think this person could attend the hearing? And sometimes they say, no, it would be too confusing and disruptive to their daily life. And sometimes they say yes with assistance. And we do our best to keep people comfortable if they want to come or not. But it's their absolute right to be there. And they can oppose all of these when I won't read them, but everything that I talked about before, they have the right to object to all of this. As attorneys who are filing these petitions, there are things that we can do to make it easier, like waiving bond, for example, or waiving the appointment of a guardian ad litem. But there are times when we'll actually request the court will say, we would like you to appoint counsel. And counsel can actually speak on that person's behalf. So they can say, my client wants this. And they're fully representing them. A guardian ad litem or GAL, they're going to actually be looking at it as a neutral party. So they'll say, well, the petitioner says this, and we're representing the petitioner. And the protected person or respondent says this.
I'm coming. I'm getting my bag.
But they'll say the protected person says this, and then they'll say, but based on all the facts that I'm looking at, what I think is this. And they're looking at it from a very neutral best interest standard. And there's times when where if there's any conflict, this is one of those scenarios where it's not necessarily like a straightforward path, but there would be a GAL's report or there could be a counsel's report. But basically all of this is just to make sure that we're doing what is the absolute best thing for this adult, because we don't want to be taking away powers that they should have. And if there's sometimes people will come to us and say, well, my dad needs this and I want to help him. And I've been doing this the whole time, but he doesn't like it. And that's one of those times when, okay, maybe we should have these other professionals appointed. But a lot of times, and the medical certificates are very valuable in this case, doctors can say, this is their condition, they present very well, and a very common phrase is that this person lacks insight into their cognitive deficiencies. And that's something where they might be fully aware of what's going on and they might be okay with some things, but maybe they're not actually fully evaluating information or they're relying on old information. So all that to say is that the person is absolutely going to get notice of everything and they can't object, but depending on the medical certificate and the attorneys involved, a guardian involved, it doesn't necessarily mean that they aren't going to have some form of guardianship or conservatorship or protection over them. It's case by case, but notice is very, very important. To avoid guardianship and conservatorship, that's something we can help you do at Generations Law Group. The two best ways to do it are while you are fully competent and capable of weighing decisions and knowing your assets and making all of these great decisions, you can get a durable power of attorney and a healthcare proxy. I have slides on each of those. So the healthcare proxy is a document that allows you to name someone to make decisions on your behalf if you can't do it. And in here it says you have to, with a healthcare proxy, if you're okay with antipsychotic medication, that should be in your healthcare proxy. If you aren't, it's okay not to include it. And it's also something that you would want to communicate to your healthcare agent and say, I have a healthcare proxy, I've named you. These are all of my wishes. And also, I don't want this type of medication, so it was not an error to not include it. We make sure that we include everything I said before. That could be one of those deficiencies where a healthcare proxy is not good enough. We encourage and put all of that in a document. With the healthcare proxy, you probably know this, but just in case, a healthcare proxy is something where you name a person and possibly an alternate or two, but it's not something that's immediately effective. So say that I signed my healthcare proxy today and I named my husband and a child as my agent and my alternate. My husband can't start making healthcare decisions for me just because he wants to, just because his name's on the paper. The healthcare proxy will set out what needs to be done. But typically, it's the opinion of a licensed physician who will write a note saying, I'm activating the healthcare proxy based on these facts. And again, it's not about bad decision making. It's about uninformed decision making that's putting someone at risk. But we have a template. They have to fill in the medical details. But when we need to have a healthcare proxy activated, we can tell the doctor, this is the type of information we're looking for you to make this judgment. If you have, say that you lose capacity for a while, whether for an illness or a medication or a medical procedure, and then you come back to and you're fully capable again of making decisions, it can be activated and deactivated. It's something that your doctor can work with you and your agent on to make sure that you're protected when you need to be protected. This next form is about a slide, sorry. It's medical orders for life-sustaining treatment. And I wanted to clarify that this is a medical form, not a legal form. And this is one where people talk about DNR or just ventilators, tube feeding, very specific life decision, like end of life decision making. And a most form is not something that's taken lightly. It's something that a patient or a healthcare agent and a doctor will talk about together, and they'll go through and you can mark yes or no on your preferences. Your healthcare agent can do this for you. If you have a most form, it's actually a medical order. So if there's an emergency and you have a most form, they're going to look for the form, like on your refrigerator at home, or if you're in the hospital or a nursing facility, it's going to be on your whiteboard. But that will give them actual specific instruction on what to do. Again, you can sign one for yourself, or your healthcare proxy can sign if your healthcare proxy is activated, but a guardian cannot make those end-of-life decisions. And so we'll talk about in a second how they can interact with each other. But if a guardian needs to make end-of-life decision-making, they need to go back to the court to expand their authority. So you can have both a guardian and a healthcare agent. And when you do, it's important to clarify what is the guardian doing and what is the healthcare agent doing. And as long as you have clear guidelines and communication, it's easy to work together. And sometimes the guardian will essentially take over everything except for that end of life decision making. So the healthcare agent might say, I need help managing all of this, or we had to get guardianship for whatever reason, but please just do this. But when it comes to the end of life decision making, that's where I want to be involved. The guardian can just take care of ordinary treatment unless they have that authority to do otherwise. And extraordinary treatment is like antipsychotics or end of life decision making. The healthcare proxy, to the extent that information is already included in that document, the healthcare agent can go ahead and make those decisions. And then another reason that I said at the beginning where you might have need for a guardianship in particular is that when there's controversy over whether a guardian is unsuitable or unfit, and this might happen, sometimes it's a family issue of, there's adult children and one doesn't like what's happening, or they think the parent's in the wrong place, or just they're not happy with how it's going. You can actually petition the court to change a decision of the healthcare agent, to revoke a healthcare proxy, to remove an agent. But basically, there's just a filing that you do to get court authorization. And say that you did a petition to remove a healthcare agent, then you could also file a petition for guardianship. So you could say that person is unsuitable. I would like to serve, so I'm filing this petition, or I want this other person to serve. A healthcare agent, someone with competency can revoke their healthcare proxy if they're unhappy. It just becomes a decision of, are they competent to revoke this or not? Like, what point are we at in terms of the progression of, is it activated or not? Sometimes it's that, I've lost my train of thought on this. Sometimes it's not that you think they're unsuitable or unfit, but sometimes it's opposite. It's like we want to affirm a healthcare proxy, And that's the opposite. So we're saying there's a healthcare proxy in place. And maybe maybe something was changed or something happened, but we're saying no, that healthcare proxy that they signed in 2017 is still good. And so we're not trying to cancel that out and get it removed. We're trying to affirm it and say doctors should still be relying on that. All of those types of things go through the probate and family court. Oh, here we go. So again, we're just affirming it. So we're saying they have a healthcare proxy. It's good. It has what we need. Please, let us keep using this document that we have as opposed to us needing guardianship. With power of attorney. Oh, so with conservatorship, a way to avoid it is to have a durable power of attorney. So a power of attorney in general is someone who handles legal and financial matters. The word durable is not a default. It's something that we intentionally add. So attorneys will create durable powers of attorney. And that means you're going to sign that power of attorney when you're fully competent and everything's going well and you're naming an agent and maybe a backup. But if you lose competency down the road in a year or 2 or 5 years or whenever, durable means that power that you signed is still good. It lasts through incapacity. And occasionally there are powers of attorney that are written that are not durable. And a lot of those come from the internet. So you want to make sure you're working with an attorney who's creating a durable power that has all of the authority that you need. A power of attorney can take effect in 2 scenarios. One is that it can come into play immediately. So as soon as you sign it, that primary agent that you've named has authority to act on your behalf. And the alternative to that is a springing power. And that means it's going to spring to action when something designated in the document happens. And a lot of times it's the opinion of 1 or 2 licensed physicians saying that you're incompetent. You can set out what you want it to say. Some people will say, I want my physician plus an independent one. But basically you have terms that are saying, this is my entire document, but none of this is okay until this scenario is met. People, I don't know, it's probably not 50-50. I think a lot of people have an immediate power, but mostly like if there's between spouses where there's already like a lot of joint accounts. And so really the power of attorney is a backup, or say there's an adult child who's already helping their parent with a lot of things, and an immediate power doesn't really change anything. A springing power is good. You can have a springing one even in the situations I just described, but a lot of people will do springing if, say, they're naming like their neighbor who's more than willing to help, but they're like, I don't really want them in my business right now, but they'd be wonderful if I needed them. Or if they're saying, I have this brother, he's not like the best brother, but I know he'd take care of me. But again, sometimes it's just like a privacy thing of saying, I don't really want any chance of them getting intermingled in my stuff before it's time. But immediate or springing is just a personal decision. And again, if it's durable, it doesn't matter if it's springing or if it's immediate, it's going to last. So whatever terms you put in there are going to be fine. Let me go back. So again, with the power of attorney, in terms of things that we want to see in there, a lot of times it has to do with the transfer of real estate. And that's for someone, either for protecting the house. If there's not that specific authority, then it could be a problem. We also, every document is different, but gifting is a provision that's sometimes beneficial to have in there, or self-dealing, where someone might do something that could be seen as favorable to them, even if it's not specifically. And in that case, you could think of, if there's a power of attorney where there's the ability to transfer and manage real estate and also self-dealing, and say there's 2 spouses and one needs mass health and one is a community spouse, we could use the power of attorney. And the community spouse could say, I'm transferring the real estate to me. And that's allowed because you have both self-dealing allowed and real estate. So there's a lot of terms in there. It's almost the kitchen sink, I tell clients. It's so many powers, but we want all of them in there for a reason, and everything can be tweaked. And if there's something and we're like, well, you should keep that in, we advise our clients on why some things are there. But just know if you have a really solid healthcare proxy and you have a power of attorney, you're in very good shape. And for both of those documents, it's very important to name a primary agent and at least one backup, if not two. For the power of attorney, your initial agent's going to stay in that role until something happens to them. And that means they could pass away and it'll go to the alternate. They could resign. And again, that could just be, I can't do it, or I have health issues, or it's not necessarily a bad thing, but they just, I can't do it. So it's not going to be a fluid document jumping around, but it's really nice to have a backup. And then all of that said, there are times where people will have a really perfect healthcare proxy and power of attorney and say they have only one agent left, or maybe they have two. If you're managing someone's life for them, essentially, you're helping them in every aspect, healthcare, finances, everything, it can be a lot of work. And there are people who we have helped find another person to name, because it's a huge responsibility when you're taking care of yourself and your family and you're working to also take care of someone else. So there are times when we have really wonderful documents and we still go to the court and we say, we have all of this set up, but this person needs more help, and this is why we're proposing to we acknowledge we have these documents, but conservatorship and guardianship would be more appropriate. I will say just a little bit about how we work here is if someone calls about conservatorship or guardianship, typically the first thing that I like to do if it's coming to me is schedule a free 15-minute phone call, because it's very helpful in terms of getting the lay of the land and who's involved and clarifying a lot of the things I said today, but about timing. And there are times when we say, do you have these documents or do you not? Or where are you? What's the person's connection to Massachusetts? Because sometimes people move away. But I want you to know that if you contact us and this is something that's becoming very like an immediate concern for you, you'll get very specific feedback based on what's happening in your particular situation. But I always like to do that 15-minute call because I think it helps put people at ease to know, okay, I'm in the right direction, this is what I need to do, or if we need to refer you out, like if you should start somewhere else. You know, I just know that we'll get you on the right direction, because conservatorship and guardianship aren't always the answer, but when there are issues, it's often what ends up being the result.
I want to thank you, Tiffany, for all that information. I want to thank everybody for joining us.
Thank you all for being here.
Thank you. Bye.